Okay, Attorney Steve Vondran, we're back. We're licensed practice law in California, Arizona. We are talking UDRP, domain name disputes, brand protection, trademark rights. We are talking cyber squatters. So we left off talking about having our fictional, I don't want to say fictional, it's a real company, Best Buy products. Don't ask me why I picked them. But somebody registering the name BestBuyRebates.com and being called and labeled a cyber squatter. And you have a fuming mad trademark owner. They own federal trademark rights in Best Buy products and Best Buy Inc. and all the other trademarks that they have. Okay, we talked about this could be federal trademark rights, this could be common law rights, which are use-based rights. So what's the process in a UDRP action? Who does what? Where do you go? What's the story? Let's go back to the Attorney Steve whiteboard where it's all happening. Let's talk about real quick, there's 4 different major accredited dispute resolution service providers with domain names. The main 2 being the National Arbitration Forum and the other one being WIPO, W-I-P-O, World Intellectual Property Organization. World Intellectual Property Organization, WIPO. That's a great name, you gotta love that, right? So you have these, and then you have like the Czech, you have the Czech court in an Asian form and whatnot, but I think the 2 most popular that you're going to see and hear about all the time are the National Arbitration Forum and WIPO. So they have their panel of arbitrators, lawyers and judges, ex-judges I should say, probably not a judge at the same time you're doing these cases, but you're a ex-judge, you're a lawyer, and so you're on these panels. And so when a complaint gets filed, in this case, Best Buy is upset, they're going to initiate a UDRP complaint, a complaint by the petitioner or the complainant, okay? It's somebody initiating this complaint, which is like an arbitration case. It's not a federal court case, it's an arbitration case, basically. You're not meeting in person, it's not, you know, you're not flying to Geneva where WIPO is, you're not flying to Minnesota where the National Arbitration Forum is. You're electronically filing these documents, you're paying your filing fees, you're paying for your arbitrators, okay, and it depends if you want to have 1 arbitrator or 3 arbitrators on your panel. It's the complainant can choose, and the responding party, if it's 1, they can elevate it to 3 judges, so forth and so on. But that's going to be your fees. Your fees, you're going to be looking, as far as WIPO, about $1,500 for a domain dispute, $2,000 if you have more than 5 domains. If you want to get the 3 panel because you want a little more breadth in your judges that are making your decision, you can pay extra for that, about $4,000. And if you have more domains, it's going to cost you an extra grand. Check out the prices. These prices may not be accurate. This is the price to file, to get your panel, to raise your dispute, okay, in these forums, and get your panel a portion. So we talked about the service providers. They're each going to have their own policies and procedures that need to be followed. Your complaint's going to have to meet certain standards. There's different procedural rules as far as how the case needs to go through, so that's something you're going to need to keep in mind. So we talked about that, we talked about e-filing, we talked about the difference of these providers. Most of your cases are going to be heard by the National Arbitration Forum, a good percentage of those. So let's get back to now the complaint by the petitioner or the complainant against the alleged cyber squatter, the bad guy that's registering domains trying to make money as a profit, right? So anyway, you have this going on, but what's the test? Basically, you file the complaint. When you file as the complainant, you need to make sure that you have the evidence you need to meet your burden of proof. It's your burden of proof as a petitioner bringing it forward as the complainant. You need to be able to establish 3 things. And we're going to talk about those in 1 second, but you're going to file the complaint, you're going to serve it on the other party, check that off your list, and realize that you have the burden of proof, okay? These are things that you're going to keep in mind. Now, if they don't answer, figure 20 days is generally as a response date. If they don't answer, just like a regular court case, you can seek to take their default what we call default judgment. And in this case, in the field of domains, you would want to get an order transferring that domain from them to the trademark owner. So that's really what's going on here, is you're trying to get that transferred back to you. That's what a UDRP case involves. Okay, so the whole process from start to finish, you're looking at about 60 days. Let's check that off. That's why I say it's faster than a federal court case, less expensive, and it gets right down to the meat of a very basic single issue is, and let's keep this in red, one, you have to show that you have a valid and enforceable trademark rights. Valid and enforceable trademark rights, number one. Okay, and again, that can be, as we talked about in the first tape, it can be a federally registered trademark, it can be use-based common law rights, either one. So you have a valid trademarks. Bear in mind, as to this first element, the stronger your mark is, the more that's going to weigh into the equation. It's just a factor, it's not going to decide. Just because you're Best Buy doesn't mean you automatically win. Even Google has lost a couple cases. I think there was a case called Grovel, something like that. I'll brief that in another case because it's actually Google actually losing a case. But, you know, it doesn't mean you're going to win, but it is a strong factor that these panels are going to look at. So you need to prove, number one, valid and enforceable trademark. Two, you need to show that the registrant, this guy, the person that registered the domain, has evidence of a bad faith registration at the time that they registered the mark. How do you show that? I mean, it's not easy. You got to go back and look and see, has this person been cyber squatting on other cases? Have they been in other UDRP proceedings and lost? Are they a known cyber squatter? Are they trying to divert your traffic? You need some evidence of a bad faith registration, okay? And bad faith use. If somebody just registers a domain and does nothing, you may have a much harder case to prove, okay? If somebody registers Vondren Law Firm, it's probably available, I should probably go look and grab it. If somebody registers Vondren Law Firm, I may have a hard time if all they do is sit on it and all they do is register it and just hold it for whatever reason. I may have a hard time defeating them in a UDRP. So you need to show the evidence of the bad faith registration at the time of registration and the use. Okay, they're creating the Best Buy rebates.com. They're trying to basically traffic in your name or divert traffic from your site to theirs. Things that would legitimately upset a trademark holder. So that's one, is the valid trademark or the service mark. Two is the evidence of the bad faith registration and use. And three, you need to also show, as the complainant, it's your burden of proof to also show that they have no legitimate rights. Now, if there's another firm, I'm not the only Vondren in town. If there's a firm in New Jersey using Vondren Law Firm, that's a legitimate use, right? I mean, they're allowed to do that, barring some other federal issues that may be at play. If you have a federally registered trademark, those are going to give you other rights. But you need to show, as a third part of your burden of proof, no legitimate rights. This party has no legitimate rights. Okay, so you can see that it's not necessarily an easy thing to prove. It's not a slam dunk. But if you go through the factors and in your complaint you're making these arguments, you're putting these things forward, you're showing the judge, the panels, what's going on here. You're giving them not only your complaint, but you've got some declarations. You may have some case history with this person in other UDRP complaints. You may have some evidence, some web pages, some things you want to show. You may want to attach your federal trademark registration and show those kinds of things. So that's basically the three-part test. Now when we come back to our final video, video number 3 in this series, we're going to hit on some of the defenses. What do you say when somebody's calling you a cyber squatter and has the nerve to call you a cyber squatter? What are you going to say? Stay tuned for video number 3. It's the final video. I swear I'll wrap this up, and we'll be right back.